Welcome to ABC Virtually. Happy to have you guys signing in. We will get started with the presentation in just a couple minutes. I'm letting a few more people trickle in. But I'm going to go ahead and introduce our speaker for the day. Mr. Greg Norton with Crossgunner Witherspoon and Gouches is here today. And I know many of you have heard his presentations in the past. Greg does a thorough and very informative job on his presentation. Today's topic is controversial, confusing, and a little bit crazy right now. And Greg's going to try to cover as much information that we know right now, but I'm sure there's going to be plenty of questions that come in. So don't be surprised if a few months from now we end up posting another presentation to give everybody an update, because that's what we're doing, is updating all the time, and this is the forever changing, evolving situation. So very thankful to have Greg here this morning to kind of fill us in on what we know now and help us as we move forward. But without further ado, I'm going to let Greg kick us off. Thanks for being here.
Thank you, Megan. Welcome everyone online. Appreciate y'all joining us today. Thanks to ABC for having this presentation. If you've been in one of these before, I'm going to say some things I guarantee you've heard before. I don't have a tremendous amount of updates, but there have been some very significant movement. We're going to talk at the national level. We're going to talk at the state level. And I would like to hear from some of your experiences. If you're online, please participate. I'm sure some of y'all have me tapped down and you're just listening. That's great. Pull up that chat bar. If you've had an experience you're going to share, you don't have to say what company you're on. We won't be on a recording or anything like that. But just trust me when I say you're not alone. One of the reasons we did this presentation is because I was in a meeting with Bill and I said, man, we are getting called lately about medical marijuana. Apparently during the great quarantine of 2020, everybody went out and got the medical marijuana card, which we didn't realize until everybody had come back to work. And then when people got off the unemployment surplus, there were more hiring, and we're having more and more. What do we do? So we thought this was a timely session to go over where are we in Arkansas. What are we seeing? What are we expecting nationally? There's been some federal legislation proposed. What impact will that have on construction industry in particular? But even if you're not a contractor, if you're a vendor, supplier, this affects every Arkansan. You all, as Arkansas residents, assuming you are, have a constitutional right to smoke marijuana. That's your constitutional right. And so this is important stuff, and it affects all of us in one way or the other. And hey, if you have a buddy who's not in ABC and you want to tell him or her, I'm not sure if you're doing that right, you might want to look into it. This is kind of one of those topics you might want to look into that because it is important stuff. So we've got our cheeky title. It is a growing challenge. Not a lot has changed under Arkansas law. Drug testing. Some people ask us, can we still drug test? Yes, and you should. There's still lots of other things to test for besides marijuana. That's what we're going to be talking about today. Also prescription drugs, oxycodone, hydroxy, all these, fentanyl, there's other things, meth, all these other things that are still very risk sensitive issues. So even if it's been prescribed by a doctor, it can still be unsafe, it can still be a threat to your workplace. So want to make sure we're doing all this right. So with that little overview, I'm just going to dive into marijuana. If you have any questions on other drugs, we can talk about those as well. When I say drugs, I mean legal drugs like prescriptions and meth, fentanyl, cocaine, whatever people are doing these days. So it's no surprise if y'all pay attention at all. The people who are talking about the Green Wave is happening. Is happening. We now have 38 states, 40 jurisdictions that have some form of lawful marijuana use. That happened real fast, okay? About a decade for that to happen. California has had it for a long time for medical use. Washington, Colorado went in 2015 with recreational, that kind of broke the mold. In the last 6 years, we're now up to 9 states, including DC, who have legal recreational use. This is a 2020 Gallup poll, which apparently, this is a funny little side thing. Gallup's numbers on the poll skyrocketed last year. Everybody's sitting at home bored answering surveys, apparently. But this is a legit Gallup poll. 68% of Americans support making marijuana fully legal. Okay, That is a staggering statistic, and that number is only going to go higher as the generation shifts from older to young. Okay, millennials, Gen Zs don't have that stigma of marijuana that baby boomers have. It's just a fact. So it's going to go greener for sure, as sure as we can be. 90% support allowing medical marijuana. And I would hazard a guess that the 10% who don't are probably an age demographic that will be not around in the near future. So this trend right here just shows you where we've gone. The graph there is from the same Gallup poll supporting legalization. If you look at that, just look at 2012. We were at 44%. In 2020, we went to 68%. That was the green wave. It happened and it happened fast. So marijuana laws are changing. There are legislative ballot initiatives in all 50 states to enhance marijuana use. There are bills proposed to decriminalize marijuana. There is a federal legislation passed by Senator Cory Booker. You all may have heard of him. It's called the MORE Act, M-O-R-E. And it criminalizes and declassifies marijuana as a Schedule I narcotic. So it would free it up for more medical testing. It would free it up for human use. It would free it up for take all DEA enforcement out of it, essentially. And a lot of people are for that because, you know, whether it's legal or not, people are using it. And again, the wave is happening. So that most likely will be happening soon. What does that mean for Arkansas? If the federal government decriminalizes, does that mean it's legal here in Arkansas? No, we still have our own constitution, we still have our own laws. And based on this last legislative session, I honestly don't know. My first thought when we were talking about this in the last year or so was, well, there's no way our legislature would legalize marijuana, I think. But to be frank, and I know I'm being recorded, I think I can speak openly about this. There's a large group that's very anti-governmental restriction, unless they are restricting you from restricting others. It's a little complicated, face masks and whatnot, but you know, we don't really know how a vote would shake out. There's going to be a lot of pressure outside of the metropolitan areas of the state, most likely to keep it criminal. But that said, remember this passed, medically used passed in Arkansas, of Arkansas voters, which is usually an older demographic, by 53% in 2015. So 6 years ago, 53% of the state said, we want medical marijuana. And I have to remind people of that, because I know we all have our own personal opinions on it. I've got stories of my own. I've got stories that people told me about, you know, the successes of medical marijuana and whatnot, recreational use. I'm sure we all know somebody who's down to Colorado and went to one of those stores for a funny gummy. You know, it's just kind of being normalized. So all this legislation, this, to Megan's point earlier, this stuff is changing. Literally, the legal landscape is shifting beneath our feet. And how do you deal with it in the workplace? It's not going to be overnight. At some point, when it does get decriminalized, or if it gets decriminalized, it will be treated more like a narcotic that is regulated and will be prescribed. So right now in Arkansas, a physician is barred from prescribing marijuana because it's illegal. It's a legal drug, an illegal drug. And as an illegal drug, a physician cannot recommend it as treatment. All they do is they certify someone as having one of the 12 enumerated physical conditions, whether it's AIDS, cancer, Crohn's disease, ulcerative colitis. There's some very specific diseases. And there are some general ones. The catch-all is if you have had any localized pain for a period of 3 months while you're receiving treatment that's not approved, that qualifies you for medical marijuana product. Well, for some unknown reason, I have no idea what it is, my back hurts a lot. And so at the end of the day, I'm like, man, I've got this back pain. I don't know what it is. But I put my, lidocaine or whatever that stuff is, you're up on there and stretch. I've been treating it. So I could probably go qualify myself for a medical marijuana. Probably. doctor, there's a couple clinics who pretty much, if you truly feel you're in pain, and you tell them, the doctors cannot not believe you. The Hippocratic Oath says you treat every patient you find out. And so the doctors can certify those conditions. You get the medical marijuana card. You are now lawfully entitled to use, to possess and consume marijuana in the privacy of your own home, in the privacy of someone else's home or establishment that invites you in to use it. But it is still prohibited from any public use. It cannot be brought to work. It cannot be consumed at work. You cannot be under the influence of medical marijuana while at work, or actually operating your vehicle. All of it is still very illegal. So when we talk about legalizing it, there are some issues. So this is just a funny little map, basically, that shows some of the differences. The blue states are fully recreational, the green states are medical, and the purple states have some form of CBD or THC. I don't know the science behind CBD. I know enough to know that people can get in trouble. I got a couple slides here. I talked to some ABC members who had some issues with CBD popping on a test. When you do, they took that pill from the tobacco store, you go to Walmart or Walgreens, and they go, horny goat weed, and here's your CBD pills, and you start popping whatever, and it smells good, and you take it, next thing you know, you're at random drug tested, and it pops for THC. Do you fire a person for that? I bought it at the gas station. It creates some issues. I'm going to go very briefly on CBD products and synthetic marijuana. What is it? This is just some stuff for y'all to look at. Again, it's not just do science. But I can just tell you that the cannabis plant has 2 strains. If you look down here on step 4, there's an optional step to remove the THC. If you know anything about marijuana, THC will get you the high, the big high. But there are still oils and things that can be extracted from the plant itself without the THC. That's supposed to be an anti-inflammatory, a natural, just like those folks selling Rodan pills and all these essential oils. This is an essential oil to an extent. It's a plant they grind up, you rub it on your body, or you ingest it. But there's 2 species, hemp and marijuana. The kicker is, if you're wondering like me, how do they sell this stuff? They have these brownies and cookies in all these stores. Wow, I don't understand how it works. It's because it is a hemp product. It has had the THC removed, but by law, it can still have up to 0.3% THC content. So that's where, but here's the other kicker. There's no regulation of hemp. I can go grow a hemp plant in my backyard, package it, and sell it. No one's going to say, yes, this is hemp. No one's going to, there's no testing, there's no ABC enforcement. It's just the Wild West. They're working on that. But until that happens, you got this guy or this lady who goes and buys the pills at the gas station, pops them, thinking my back hurts, maybe it'll work, and next thing you know, they sell drugs. That's all it is take it with my horny goat weed. I've never smoked marijuana. I didn't do a brownie. I didn't do a gummy. I promise. So we're going to talk about what you do with that in the testing here in a little bit. Again, the issue is, by law, anything under 0.3% THC content can be unregulated hemp product, but it still has THC in it. The problem is a lot of these unregulated suppliers don't really lie by that. So, 0.3 is enough to pop on a test. The MROs, the medical review officers who look at the urine analysis, do their science work and tell if it's the level of THC present in the stream and then all of the bloodstream, and then use a body mass index something to determine how much you consumed and when you consumed it. But the science is not perfect because marijuana has been so illegal that there's very limited human testing, things like that make it very difficult. So again, you can go to Walmart right now and buy CBD lotion and rub it on your body, and it's supposed to help. I've tried it. I got the big man Jamba, whatever CBD content. I'm like, does this work? I'm on getting hurt, actually. I was like, I gotta try this. And it didn't do anything. Like, I don't feel anything. I don't know if it
veterinarian recommended CBD dog treats for my dog who has seizures. I'm pretty sure I got ripped off. But my wife is sure that it's helping little Gordon with a seizure. So, you know, two people in the same house can disagree over whether CBD actually does anything. As long as people believe it helps, there's going to be sufficient for them to take it. And we don't really want to get into regulating what our employees take for pain management. We don't want to know, okay? We don't want to say, oh, you're using CBD. Well, tell me about your ongoing back pain. Now you got an ADA issue. All right, so why is this an issue? Why are you all here? I'm not going to go too far into this. You probably heard me talk about this exact slide in past ABC presentations. Some of you I recognize for sure have. But just to lay the groundwork, why does it matter for employers specifically? Well, when this passed, Act 98 amended our Constitution, okay? Remember, this is a constitutional right. This is on the same enforceability of your freedom of speech, your freedom to carry your firearms, possess whatever, you know, your land, all those fundamental freedoms. This is the same right we now have as our candidates. So I want to drill that into people's heads because I think we forget this. It's not just a bunch of hippies sitting in a closet and banging on a drum, you know, doing this in the dark. There are the majority of the Arkansas residents who voted for this, support this, and it's a constitutional right. Now that has to be balanced with safety. Obviously, it's an issue for employers. The constitutional amendment itself, I'm going to come back to this, had rules for safety sensitive positions. And it said, you know what, if you're in a safety sensitive position, there's so much risk involved with having something happen, somebody that's positive for marijuana, that it can be balanced. But it is a constitutional right infringement for an employer to discriminate against an individual in hiring, termination, or any term or condition of employment, or otherwise penalize them, meaning don't give them the promotion, don't give them the bonus, don't give them a work truck, whatever it could be. They are entitled to the same terms and conditions as they were not protected by this provision, based upon the individual's past or present status as a qualifying patient. Not going to forget about the designated caregivers. Not going to talk about that today. Those are people who take the elderly and the sick to their appointments, and they can have a limited care, basically. They can go to the dispensary and buy, you know, their 2 ounces every 2 weeks. But the constitutional language is important. I'm going to mention this. I could spend the whole hour on this, and I was thinking, please don't. But a qualifying patient is someone who has a physical condition and who has gone and gotten a card. Like I said, back pain, 3 months, I've been treating it. You know what, I'm going to go get my medical marijuana card. I pay $50, $50 application fee. Every year you have to get it renewed. See my physician, do the whole rigmarole. I get my card. I go to the dispensary. I buy an ounce of weed. I take it home. I do whatever you do with it. But I don't smoke it. I back out. If Bruce Cross finds out that I got my card and bought marijuana and wants to take adverse action against me, I'm going to get paid. Because he just violated my constitutional rights. And I know it. So that would be illegal. But what happens if I actually consumed it? What if I decided to smoke or drink the tea or whatever? That would then make me a current user. I'm saying this because there is a legal distinction under some of the state laws that extend to protections for card holders and users, or users of medical marijuana, lawful users. Our law says qualifying patient. It does not say current users. So there is a group who has the mindset that once you hit that joint, you are no longer protected and we can retaliate and discriminate against. The only people in the state who can decide this question for the Supreme Court, and they're about 3.5 years away from getting to this. There is a lawsuit filed right now in Washington County challenging This provision with regard to safety-sensitive nurses in Washington Regional Hospital, class action, they filed it. I'm sure the judge is gonna order, however he's gonna order, and if it doesn't go the way they want, they're gonna appeal it straight to the Supreme Court. That's still gonna take about a year and a half, 2 years, maybe longer. So we don't have that answer. We haven't had that answer for 5 years. But one day we will know whether users are still protected from the anti-discrimination provision. Until then, our advice is to treat someone who is using the product they're qualified to take under their constitutional right, treat them the same way. Go ahead and don't discriminate, don't retaliate. And discrimination is, you can lawfully discriminate. We discriminate every day. If you come apply for my firm and you're wearing an LSU shirt, there's the door. You can put in an application. But I can discriminate against LSU fans for that. I can't discriminate based on race, national origin, gender, disability, veteran status, and the list goes on and on. So medical marijuana users, I personally take the position that they are still protected. I recognize there's a question, and I want you all to be aware. So, if you have someone in a safety-sensitive position, under the Constitution, they are in a special category of exclusion from the anti-discrimination provision. They can be excluded from their job if they're working in a safety-sensitive position. Y'all have all heard this. I'm not going to spend much time on it. This is literally taken straight out of the law. This is what it says. What I have been amazed by is you see how this is bold and underlined right there? Lots of businesses have not done this in writing, and the constitutional amendment specifically said, if you want to exclude someone from a position that you deem safety sensitive, it better be designated in writing. It doesn't have to be chiseled on stone, it can be in an email, you can write it on a loose leaf paper, throw it in your desk drawer, I don't care. As long as there's a list of jobs that are designated as safety sensitive in writing. And the standard is any job which, while the performance of the position is going on, if under the influence of marijuana, may, not will, not does, may constitute a threat to health or safety. That's the standard. They didn't list 5 examples, but notice the catch-all down here. This is an or any job in which a lapse of attention could result in injury, illness, or death, including without limitation, a position that includes the operating, repairing, maintaining, monitoring of heavy equipment, machinery, aircraft, motorized watercraft, or other motor vehicles as part of their job duties. You're welcome, ABC. We worked really hard to get something like that in there, because without that, we would have been stuck with it. So that catch-all is very helpful, because there's a lot of jobs at your companies, your businesses, who may be a direct threat to someone's, to an injury, illness, or death, operating vehicles, or even repairing. If you got a crane operator, or some heavy D12 bulldozer, or whatever those big giant things are, if something goes off, that can easily kill someone. So those positions can be deemed safety sensitive. You probably won't have many of these, but again, the standard is anyone who may constitute a threat to health or safety. With that said, and I'm speaking up so the people on Zoom who have me tab down and start paying attention, and I'm going to check later, no, I'm not. The positions that you deem safety sensitive should be analyzed for the job duties they're actually performing. It's not what job duties they could perform. It's what job duties they are performing, and if those job duties being performed under the influence of marijuana could result in injury. I've had a lot of clarifying conversations with professionals from all levels of business, and we got to make clear they have to actually perform the job duties, and the job duties that could result in injury are what qualifies the position as safety sensitive. Also, if you have first question when I talk to contractors or anyone in the construction industry is, well, everybody in our company is safety sensitive. And you're probably sitting there thinking, everybody is. They may be. I've had a few clients we've talked to, and we've done the analysis and said, you know what? Yep, everybody. But if you have a receptionist, or if you have a part-time payroll 2 clerk who just enters ledgers and, doesn't drive for the company, doesn't have to make any runs to the bank to drop off the deposit at the end of the day, all that's done by full-time people. If you have any positions that could be deemed non-safety sensitive, then we would encourage you to classify them as non-safety sensitive. Because if you're ever challenged on your classification, which would only happen in a lawsuit, there's no enforcement agency as of now, that could change. In Arkansas, the Department of Labor does not enforce this. You're not going to get audited, you'll only be sued. It would be in civil litigation.
Greg, quick question.
Yeah.
Online, and you kind of just answered it, but just to make sure I fully got it answered. Do the safety sensitive positions need to be in writing as a whole list, or do they also need to be included in the job description?
Great question to whomever you are. I think you want to start with just creating your master list. And then if you're updating job descriptions, which you should be doing regularly, that's another thing. Listed on there, safety sensitive, all you have to put on there is this job position is deemed safety sensitive pursuant to Act 593 of 2017. If you can tell, I've been rolled off my tongue a few thousand times, it has. And when you're doing a job posting, so if you post a job, we have an opening, put this job position is safety sensitive for medical marijuana purposes. Because I've gotten tons of calls this year from people saying, they call and say, hey, I saw John's got a marijuana card, is that a problem? If you don't have it on the posting, if you have it on the posting, you can say, actually, if you look at the posting, it has been deemed safety sensitive, so you are not qualified for this position. If you're a current user, that's the more safe approach. We're going to get to the high level now, just 1 second. But before I move on, I have to mention this. Hot off the Attorney General's desk this month, General Rutledge clarified a longstanding legal interpretation issue. If you notice right here, for y'all on that side of the room, the 3rd bullet, any job that works with confidential information or documents pertaining to criminal investigations. Does anyone notice there's not a comment right there? A comma, not comment, comma. Because of that lack of comma, there has been an inordinate amount of legal bickering over whether the confidential information has to be related to a criminal investigation. To show of hands, sorry for people on Zoom, and there's no wrong answer here until the next slide. But there's no wrong answer if you think, who would say, in just plain reading of that language, that the confidential information has to be tied to criminal investigations. Okay? 5, who believes that it does not have to be tied to criminal investigations? It could just be working with any confidential information. Yep, for those on Zoom, the strong majority was the latter. And I think y'all cheated and read the AG opinion because that's what Leslie Rutledge said. AG Rutledge says, no, it did not have to be related to criminal investigations. I just have a picture here for you. You can Google this opinion number 2021-031. And now this is just an opinion from the Attorney General. The courts can still say, no, it has to be related. If the legislature intended it to be an or, a disjunctive or, they would have put a comma, but they didn't. I think the courts give the legislature too much credit sometimes, but that's just me. So, as of August 2nd, we have relaxed our recommendations. And if you have persons who are handling confidential information as their jobs, and when I say handling, I mean they need to have access to, they need to be able to disclose, they can't just, review a bid sheet or something. I think they have to be able to really somehow let that information go. Personally, I don't see how if I'm a marijuana user and I smoke marijuana every night, I don't know that me coming into work is gonna make me erratically discharge, confidential information to the internet that can never be captured again, and we lost all the profit. I get though, if you're operating heavy machinery and a lapse of attention may result in someone's death, I get that. So I could keep talking about that, I'm gonna move on, just for time's sake. Again, I wanna make very clear, this is the last definition slide, this is straight out of the act. You cannot be under the influence of marijuana at work. Now, for drug testing purposes, there is an issue. To be under the influence means that you have to do some observed behavior, right? Because if I've got my medical marijuana card and I come into work and you say, you're stoned, and I say, no, I'm not, prove it. We'll go for a drug test. Well, yeah, I'm gonna test hot. I smoke a bowl every night. It's the only way I can treat my Crohn's disease. What's gonna happen? I'm gonna test positive. What are you gonna do? Nothing. Because I'm admitting it. Now, do you send that person for the drug test? Do you still send them if they say, I'm gonna test positive, save your money. What's it cost? $60 or something for a test? Save your money. I'm gonna do it. I smoke every night. Are you gonna send me for a drug test? For those of you on Zoom, no one's nodding their head, but I'll give you the answer anyways. Yes, you should, because to determine when someone's under the influence of marijuana, you can use any of these factors to show that there was a reasonable suspicion that the individual may be under the influence. The employer must have a good faith belief that they were under the influence based on any of these factors, except a positive drug test alone is not enough to take action against a qualifying patient in a non-safety sensitive position. Makes sense, right? If I'm that part-time accounting clerk too, and I don't do anything safety sensitive, if I get tested on a random, I'm gonna test positive. Is that enough for you to take away my constitutional right to consume medical marijuana? No. Not under the current structure. No. But if I'm under the influence of marijuana, even if I'm in a non-safety sensitive position, I'm still breaking the law. So what do? You have to have a reasonable suspicion. Your drug test has to have something else for non-safety sensitive. It has to be a positive drug test plus observed behavior, information reported by someone deemed to be reliable, video footage, records, words, slurred speech, any other information reasonably believed to be reliable. I mean, this is broad here. This is a bone for employers. Anything, Cheeto dust, Willie Nelson out of Monomocan, I don't know. Anything that is reasonable to create a good faith belief plus a drug test is enough to terminate someone in a non-safety sensitive position. Do you have to terminate them? You do not have to, but you can. They are now removed from the protections of the anti-discrimination provision. But if they're in a safety sensitive position, you don't have to have everything else. Just the positive drug test. They can be excluded from a safety sensitive position. Yes, sir.
Lawful video surveillance. So if I, as a safety officer, am on site and I perceive what I think to be a type of behavior or appearance, if I brought that individual into my office and wanted to do an interview with them to see how they react to questions, stuff like that, am I allowed to video that interview?
Yes. Arkansas is a one consent jurisdiction for recording. As long as one person who's in the recording knows that they're being recorded, whether it's audio or video, you're allowed to record. Will employees like it if you pull out a video that you didn't ask them if they could record? No, they will not. Within your rights, we've got a couple people who sued, I think, I don't have anything to confirm this, but just on my speculation, when they pulled out that we were secretly recording the investigation meeting, and then when they played that for them later, flew off the rails and we got a lawsuit. People don't like to be secret. You can do it, one person in the recording consents to the recording. Now, if they're in public, lawful video recording also is if you have security cameras on your property, it's your company property. They don't have any right to privacy at work, okay? Except for restrooms. Please don't put cameras in your restrooms. But you gotta be careful when you're on, you know, you're in a, I'm trying to think, a job site, but you're not actually within the fence. You're out there where everybody parks, everybody's smoking a cigarette, talking. Somebody pulls out their phone and records the person. Do they consent to that? Is anyone in the recording has consented? If they turn that into you, is that a lawful recording? It depends. So there's the use of employee coworkers, video footage is dicey, and I would not encourage that. I mean, put on notice that the film, watch it. But keep in mind, there are some limitations to lawful video surveillance. But your answer, yes, you can, and that would be totally fine, with a caveat that it may incent someone that you end up terminating. And then here's the other risk. If you terminate someone from a position because of their use of medical marijuana, whether they were under the influence or not, what do you automatically know about it? What do you have to do to get a card? What do you have to have? A serious health condition. You gotta be real sick or have a terrible back. Either way, you're disabled under the Americans with Disabilities Act, and you're disabled under the Arkansas Civil Rights Act. The state law still protects someone from termination because of their disability. Now, medical marijuana use may not be, may not be protected. I don't think it is, unless it's within the Constitution. Okay, so that was my quick overview of everything that's happened in the last 6 years. This is the nuts and bolts. If you're on Zoom, take a look at this slide, number 7. It's number 17, although it's not 17 at this amount. Y'all's welcome. So what do you do when you're in drug testing and you have someone who's a non-safety sensitive, I'm sorry, they're a non-medical marijuana card holder and they test positive? Nothing's changed. That's an illegal drug. You apply your policy however you want to apply it. So if you want to reject that applicant that's not being qualified to count as a drug test, you can do that. Now remember, you're not drug testing until after you've already offered the job. So you've already deemed them qualified for the job, but when they test positive, they're no longer qualified for the job. You can rescind that, or you can hire them with conditions. You can give them a chance to clean up. Whatever you want to do. I'm sure the insurance guys over there are like, not whatever you want to do, but from a legal standpoint, not necessarily risk. You can hire that person, or you can not. That's why I just put continue on. However you've been handling your drug testing policy the last 20 years, do the same. If you want to change that policy, you can do that. I'm going to be careful how I say this, but there are some businesses in Arkansas, for sure, that are no longer including marijuana on their 5 or 10 panel drug screen. They are not testing for marijuana anymore for the pre-employment. They don't care. And frankly, with the labor shortage this year, a lot of people are feeling their backs up against the wall. They might care, but not enough to lose out on all the businesses out there. We got to get bodies in here. If they got a medical marijuana card, I don't really know. I don't know about it. I don't care. But as long as they're not under the influence at work, you should still reasonable suspicion test, post-accident test. If you random, do you want to include marijuana for random? Yeah, and this is for all applicants, not just people with a medical marijuana card. So I mean, that's a big change. And again, these aren't just all coffee shops up in Northwest Arkansas. I'm talking about some manufacturers, some significant operations. So that's their decision, and your company has the same decision. I'm sure the safety team probably wouldn't like that, and I get it. But that's one of those areas that's kind of changing. So whatever your policy is, continue applying it for any non-card holders. If they have a card holder, if they're an applicant, We'll talk about if they're a current employee next. If they're an applicant, you have to first decide if the job safety sensitive. Hopefully you put it on the job posting, all that stuff. Then if they are a card holder, and we first said don't ask. Kind of to the point where I'm not really sure about it anymore. Because when you're asking, do you have a medical marijuana card? You're asking, are you disabled? So the EEOC had some real heartburn about that early on. It's kind of gone away. But most of the time they come in and say, hey, I got a medical marijuana card, so I can make a problem. They put you on notice. So if they put you on notice, then you say, okay, are you engaged in the current use of marijuana? Meaning, are you going to test positive? And they say yes or no. If they say yes, we're going to proceed. But if they say no, remember, if I got my card and I went to the dispensary and got my weed, and I got home and I did what I was going to do, and I got it right here, and I just decided, you know what, I'm not going to do this. I have not broken any laws. I'm not going to be a risk. I'm not a current user. I'm just a card holder. And under the Constitution of the great state of Arkansas, you can't do anything to me because of that, because of my card holder status. That is for sure. If I did take a little toke, then you got to decide, is the position requiring non-use? Yes, obviously, if it's safety sensitive. If it is not safety sensitive, then you can test and you can hire upon a negative result. So if they say, no, I'm not using, well, if they say they're engaged in current use and they're in a non-safety sensitive position, you send them for a drug test, and then you can hire them. I don't think that's a risk issue. You probably want to consult with your insurance carriers, but they haven't done anything. If they're non-safety sensitive position and they have a negative test, what's that good faith belief that they've been under the influence of marijuana? Because that's the only way. Use off the clock in a non-safety sensitive position is protected. You can't do it. You should most likely hire that person if they're otherwise qualified. If they're in a safety sensitive, then you have two options. One is you're not qualified for this position. Sorry. Move on. The second is, would you be willing to stop? If you want this job bad enough, we can hire you contingent upon you passing the drug screen in 30 days. Stop using, you can keep your card. We don't interfere with anyone's card holder status, but current use would disqualify you from the job position as a team safety center. So do you want the job or do you want to keep using marijuana? For some people, they're going to say, it's the only reason I sleep, it's the only reason I eat, it's keeping me from suicide, and I've heard all these things. And so that's not much of a choice for them. But for some people who may just have occasional flare-ups and they have other medication alternatives, then you might want to give them the opportunity to cease use and take the job. That is the approach we've been doing with a lot of people who in your current workforce. If you've got someone who's been there 10, 15, 20, 25 year veteran of your company, old Greg, man, everybody loves old Greg. He's got the best Baileys and his parties are the best. And you don't want to get rid of old Greg if you don't have to, right? He's a good employee. We train him. He's over this division. He's got all this institutional knowledge. He's got all this industry knowledge. He's a valuable asset of our team. We had no idea Greg had a medical marijuana card because of back pain. If you don't want to have to fire me, you can work out where you come up with a mitigation plan and say, we're going to put you on unpaid leave, paid leave, how are you going to do it? Cease use. If there's modified job duties, you can talk about that. But if we're going to retest you in 30 days, then you can continue retesting. But if you do that for one person, you can't just do it for your old buddy Greg, who's a white male under 40. You got to do it for everybody. Make sure we're doing everything. Then you can get it to a Title VII or an age discrimination or disability discrimination claim. If you do it for Greg, because he just has back pain, but so-and-so's got AIDS, and we don't want that, right? We've all seen the movie Philadelphia. You can't do that. So the disability protection is still there, the age protection is still there, the gender, race, national origin, all that's still there. need to apply that unequivocally across the board. All right, got through the bread and butter. Anyone have any questions on that? Go for it.
So when you got to the current employees, you the way your narrative went was you're gonna offer them to trying to get clean every 30 days, but you never said whether at the end of that 30 days, are you gonna fire them, or are you just gonna keep extending it? Like, if after 30 days, he or she was still positive,
A lot farther than that, yeah.
you can?
Yeah. Well, they're not a safety sensitive position. No, I'm just talking about safety sensitive position.
Okay.
If they're a non-safety sensitive position and you have no information that give you a good faith belief that they were under the influence of marijuana at work, or if they were possession or selling it, then you can't take action against a non-safety sensitive. The only way you can take action against a non-safety sensitive cardholder is if they're under the influence. And so that's why you gotta have something else, slurred speech, lethargic behavior, whatever. For safety sensitive, as long as you're currently engaged in the use of marijuana off the clock, you're gonna continue testing positive. And you're operating heavy equipment, or you're driving a company truck, you're going job site to job site, we don't want you getting a minivan full of children, that we're gonna do a post-accident test, and our insurance provider could potentially deny and claim for liability coverage because you have marijuana in your system, and we now knew about it. We now know you're using marijuana. We let you be in that position, driving a 10,000-pound missile down the highway with whatever equipment you got on the back, and you hit a van full of kids. That's why safety-sensitive jobs get that exclusion. The risk is too great. And so it's a public health, public threat issue. That's why I struggle with confidential information. It is important. I don't downplay it at all, but there's a difference. So in a safety-sensitive position, somebody who you find out is using, you can say, you're not qualified for this job if you're using marijuana. And that's conservative. You can say, even if they're a card holder, and there are some attorneys who would say they have a medical marijuana card, they can't be in that job. I'm of the camp that says they probably should be using marijuana for that as well. But that's when you can say, you're out of the job, we're firing you, we're reassigning you to some non-safety sensitive position. Or if you want to stop use and retest in 30 days, if you give a negative test, we'll continue you on. That also shows anti-discrimination. Which is, we don't care if you're using, you just can't use it while you're doing this job because it's too risky, it's too much of a threat for an injury or an illness. Good question.
Yeah, so, and you may have touched on this, say you type out a list or you write out a list of the safety sensitive descriptions for your current employees. Do you need a signed acknowledgement from your employees that you're implementing that?
You do not. The employer has complete autonomy over designated jobs as safety sensitive. It's a good practice. I would recommend it, especially in the application. If you post it on the job posting, they're on notice. Why did you apply? First of all, you either don't read or you're not very smart, means they're probably not going to be good for this job. But if it's somebody in a position, so if you're implementing this for the first time at your company, you can designate those jobs. Look at me.
Get yourself on track.
Flashbacks this morning, back to school. If you are doing that to your current workforce, we recommend going around and explaining, oh, Greg, you're in this job, you've been here 20 years, just to let you know, we don't want to know anything, we're not asking anything, this job is now safety sensitive. That means if you have a medical marijuana card, that's your right, but you won't be qualified to continue in this role. Something like that. That's when you might find out, oh, Greg's been using the devil's lettuce for the last 6 months, you didn't know about it. Could be whatever. And so once you're on notice, you're now on notice. So if I go out and drive that company truck or operate that big rig or whatever, swing a shovel, hit somebody in the eyeball, take their eyeball out, and they're going to send it for a post-accident test, THC in the system, and we knew about it, Diana. Yes,
So what was your opinion about considering people who, get vehicle allowance? They don't drive a company vehicle, but they have a car allowance, so they get mileage reimbursement when they drive the company vehicle.
thank you for that really tough question, Lisa. Yeah, I'm gonna repeat that for the people on Zoom. The question was, what is my advice for persons who receive a vehicle allowance, meaning they drive their own vehicle, but for company business, and so they're reimbursed for mileage or use? I would treat that the same as a company truck. For our purposes, it doesn't really matter if they're in their own truck or a cross-country truck or an ABC truck with a logo on the side. That would be bad, but even if it's my personal truck that I'm doing for company business, and y'all knowingly let me go on that trip or ask me to do this duty, no one else consuming marijuana. I mean, talk to your carriers. If I can say one thing you take away from all this today, talk to your insurance carrier, because there's been a lot of change in the exclusions section of the policy, which is like 00I3N, where there's going to be something buried there that says, you know, the knowing use of an employee in the scope of their duties, you know, some type of language saying they reserve the right to deny coverage. And, you know, take an eyeball out for a young, healthy worker, that can be costly. It doesn't have to be the van full of kids going to, church that gets hit, for it to be a costly thing. Spinal injuries, back injuries, those things can be very costly. Workers' comp is an exclusive remedy in Arkansas, so coverage for your own employees will typically be covered. Medical marijuana is a constitutional right under the Constitution of Arkansas. Arkansas workers' comp rules recognize that, but your insurance coverage is a whole other matter. If there's a visitor on your job site, a guest, a client, or someone else gets in, or just a third person gets in. Good question, Lisa. Thank you. So, what did you do for this? First of all, figure out what you want your policy to be. I'll wrap all this up in 1 second. Reasonable suspicion has never been more important. Y'all are all here. That means you have some voice in your company's drug testing procedures. I hope you'll take this to whoever your decision makers are at your business and implement some type of reasonable suspicion training. We've got some ABC members who give reasonable suspicion training. We've got, take these slides. There's a checklist we give our clients that has 2 signatures, so that it's not, well, Greg reported Megan showed up with the Willie Nelson shirt on, and he thinks that's enough. We sent her for a test, she tests positive. That's 2 things you've got a good faith belief. But if it turns out, Megan stole my parking spot 3 days in a row, and I was just, angry at her, or we dated in the past, or there's some personal conflict between us, then that would undercut the reasonable suspicion. So we always request that you get 2 witnesses, 2 signatures on a checklist for reasonable suspicion, send them for the test. If they test positive, now you've got that plus. You've got a positive test plus something else for the non-safety sensitive work. That shows up and, is acting adverse behavior. And again, the checklist we have say, what were the observable indicators? Was it physical? What was it? Was it speech? Was it behavioral? Were they just staring off in oblivion? Was there constant work performance? Are they just losing a step? Something's off about Greg. We don't know what it is. Something's off. That may not be enough. We want specific observable indicators. Any other behavior, remember that catch off, anything else that could be reasonable, good faith belief. So here's your takeaway, and then we're going to have a few questions. Any questions, feel free. I'll also stick around for questions off the recording. The first thing you do is decide what your policy is going to be. If you haven't looked at it in 5 years, now's a great time to look at it. Remember at the beginning, your current workforce, I assure you, is going to continually become more and more acceptable of marijuana use as years go by. That's most likely statistically gonna happen. So if you're a decision maker who has a personal objection to marijuana, totally fine, totally within your authority. But it may make retention, or it may make hiring, marketability, and retention of younger workers more difficult. So, it may not, it depends on where you're at, what your company is, what your industry. You know your workforce best, so apply a policy that's workable for you. You may have every job position in the company may be safety sensitive. I bet you can probably find one job that isn't. Either way, you need to designate your jobs as safety sensitive in writing. If you can update your job descriptions and by the way, detail the job description with those duties that make it safety sensitive, that would be helpful. And then, decide if you're how you're gonna handle your current workers. Applicants, new hires, that's easy. You start your new policy, you apply it for all new hires. Your current workforce, you may want to talk about going around and having a conversation with folks in those positions saying, have a team meeting, do it in a group, let someone say, if you have any questions, come talk to me individually, someone may come up, you can disclose. I've had pros and cons for my whole life, it's miserable. I was on the verge of death 10 years ago, and I got my medical marijuana card. It's the best thing for me. I really want to keep my job. It's the only thing that comforts me in this world. I've tried everything else. You want me to choke down Oxycontin? Because they can do that too, but they're probably not going to be qualified for the job if they're taking a lot of pills that are powerful enough to deal with that pain. There's going to be some hard conversations. So know what your policy is before you have that conversation, and have those discussions. You'll be best suited to treat your workers fair. Avoid that test case. There's not a lot of litigation on this right now. There's a ballot initiative proposal for the next regular session. Next fall for the ballot? Yeah, 22. Fall 22, we're going to be voting, most likely, it's going to get enough signatures. We'll be voting on recreational marijuana use in Arkansas. A lot of people did think that it was passed last time, 53% said yes. It's been 6 years, it'll be 7. With all this changing, I don't know, it could pass. So we could be doing all this over again next fall. Yes, questions?
I'm pretty sure the answer is yes, but it says regarding safety sensitive positions and they initially tested positive and we give them 30 days to get clean, can we random test after that?
Oh, sure, but random, and that's a great question. Random means random. If you're randomly testing people that's not random. But now that you're on notice that someone has a past use of marijuana for at least a reasonable period of time, for I'd say up to a year, you could do what you would call a random, meaning like an unscheduled reasonable suspicion test. I would not call it a random though. I think I know what you're saying, but for a random test to be random, you're supposed to put everybody's name in a hat, whether electronically or old-fashioned, and randomly draw names out from the top to the bottom, and there's no discussion or thought into who goes into the test. And that's a true random. There's a randomizer apps or websites you can go. Every employee gets a custom number and spits out the numbers, and you go see who it is on the list, so it's truly random.
Can't you document it and spell it out that, since we've had this conversation for the next year, 18 months, that we can select who it is and get found without probable cause for drug test and have it sign off on it?
That's part of the reasonable suspicion, that's part of the plan, yes, exactly. For those online, I think you heard it, but if you want to say for the next year, however long you want to do it, 6 months, 12 months, 18 might be pushing it, but there's no bright line on this stuff. We're going to randomly test you, but it's really part of the reasonable suspicion follow. At some point, though, a past drug user becomes protected from discrimination, meaning burdensome drug tests that other employees are subjected to at some point. If they're a current user, they have no protection. But if I was a heroin addict 5 years ago and I come apply for your job, for your company, and I've been clean for 5 years, and get no reason to believe I'm going to use and I test clean. If you don't hire me because of my past use, the EEOC, I'll be at the EEOC calling a complaint on that. You you gotta be careful where that line is. Any other questions? I try never to go long. Okay, well, I really appreciate y'all coming out. My email's on here. If you want the slides, there wasn't that much stuff in there. If you want them, I'm gonna have Megan, she has copies. She can send them out to anybody who wants them. Y'all feel free to give me an email, with any follow-ups. If you think about it, driving back to work today, be glad to help. We're all just trying to figure this stuff out together and stay out of the lawsuit. Thank y'all.